Hit back with Hastings.
All right, Brett Hastings is here. We talked a lot of football. We may wander into basketball today. How you doing over there?
Doing good.
You all right?
Yeah.
How's the surfing this time of year? Good?
It has been flat. It's
Flat,
like a
little
lake
flat.
out there. Yep,
Yeah,
it
okay.
is. It
That's
is.
not good.
You know, I'm just glad to see you. You know,
Yeah, I'm here.
This is your one or two sports days here before the
Yeah,
football, the real season comes.
Exactly right. Exactly right. And
I'm just jealous.
in between vacations, if we try to squeeze in between vacations. So.
Do you like have a vacation, like a starter vacation, just to get you ready for the real vacation?
Oh, absolutely. I do. Yeah, you have to listen. I'm a grizzled vacation veteran. But I'm. Hey, for people that don't know, Sports and Courts, Brett is a terrific attorney, and he comes and talks about sports issues that affect or legal issues that affect the world of sports. The Aberdeen thing is interesting. We've talked a lot about guys getting eligible. We talked about all of them at some point, but this is one of our guys, so it's interesting. It's a Florida guy. Denzel Aberdeen played. I thought it was 41 minutes. I heard Todd Golden say the other day it was 35 minutes. But he didn't play very many minutes as a true freshman. It was mop-up time. And it wasn't like he played at the end of the year. It was a little mop-up time here and there. And then he played 3 years, and 2 at Florida, 1 at Kentucky. Now he's transferring back to Florida. You all know the story by now, that he's trying to play again at Florida. The NCAA has since passed a rule that says you have 5 to play 5, but they are not grandfathering in players that were already there. So it's not like he can say, well, good, he's good. So he's waiting for a waiver. He may file for an injunction. Brett, what do you see as the possible legalities here?
So they're going to – what's interesting is I did read some reports that they waited to seek the waiver until after the NCAA had made its decision on, the 5-and-5 rule.
Yeah.
And really, I mean, you don't need a law degree to just use some God-given common sense and say, if they're saying this is the way things should be going forward, this is fair, this is reasonable, and sort of but for the timing here, he should be able to avail himself, that's only going to help to strengthen his argument. From a strategic standpoint, what they're going to do is lay back, I think, as long as they can here to see what decision they make, right? Because theoretically, they could file an injunction either way. Right? They could do it now just to say that he should play while they're waiting for it, or they could say we're going to prevail, on an appeal of this going forward. Now, what would be interesting is where would you want to do it, right? We had talked a little bit when we were going through all of the Sorsby debacle, and it was a debacle. You could file in state court in Alachua County and say, hey, this sounds like this is going to be like a perfect demand. But you couldn't make some of the antitrust arguments that you would make on the other. You would just kind of have to carve it probably to straight state law claims, and along with pointing to this NCAA rule, you would allow the NCAA probably to remove it at that point.
Right. So
you may want to still just go and file in federal court, point to that antitrust law. But at the end of the day, you can look at their own rule and say, look, let's take fairness into account. He only played 41 minutes total. You've now decided that every collegiate player going forward should be able to do this unilaterally, 5 within 5. They have all kinds of reasons and rationale that they put into the record to support that new NCAA rule. So that's going to be really important.
All right, let me ask you a question, a follow-up. There's a group of 11 or so athletes in Ohio that have that have filed a court case saying because it's not grandfathered in and now it's going to be next year, they should be able to play a 5th year now, even though they played a lot and they were starters and whatnot. Florida has purposely stayed away from that case. Florida has purposely said we do not want to tie Denzel's case into the guys that were full-time starters and just want a 5th year because they want to keep the waiver separate. Why would they be, in your opinion, your legal opinion, what's your opinion of why would they make sure they're not attaching him to that?
Because we've always talked about these injunctions are fact-based and they're individual to that case. He has incredibly strong facts. Some of these other people that literally just paid, almost all of the games as opposed to the 41 minutes.
Correct.
You wouldn't want to be tied because there's the potential for an adverse ruling or that to be poor precedent. So that's number one. Number two, Florida is not a very pro-litigation athletic department, athletic association, or what have you. So, with injunctions, the timing can become very important, right? Because we always talk about there needs to be irreparable harm. That would be clear here, right? You'd say, hey, I'm not in I'm not trying to go to the NBA right now. I'm not trying to play somewhere else, to play basketball. This is my only opportunity that I can ever do this again. So, and what's the harm to college basketball? It's nothing. One more player, right? Whereas the individual harm to Denzel is really great. So as far as a legal test, it's that. And likelihood of success on the merits, right? I think he'd have a heck of a case without them passing this rule. With them passing this rule, I think it's really a slam dunk. Now, I wanted to find out, I don't know if you guys had even heard in other media reports or whatever, why they didn't grandfather some of these other people, going forward, because that is something that they specifically found, right? They said this will be the rule going forward, but these other people won't be grandfathered. I would believe that's because if it's these guys who had been full-time starters, right, they didn't want to necessarily allow that. It really wasn't for the Denzel Aberdeens of the world where you say, hey, this guy was a young freshman, got a couple of mop-up minutes, in a couple of games early in the season and did not really play that year.
I would think the reason they didn't grandfather it in, Hayes, jump in here, is because they decided this late and too many teams had their rosters set. I would think the teams even asked them not to grandfather it in so that it didn't screw up the rosters that they already had. I mean, you get a 4-year guy that was a good player. You're convinced he's gone, so now you replace him. Then all of a sudden you find out in June he can come back. I think that's why they didn't do it.
Yeah, I think that's a great point. In terms of Florida, is there any way that they can try to manipulate the injunction to get it in front of a favorable judge? Like in terms of venue, like how important would who hears this case be for Aberdeen's camp?
That's known as the Bediaco Trinidad Chambliss rule.
Right,
Okay?
right. So as we're saying is that you're probably going to have a pro UF judge in Alachua County, right? So that may be one of the reasons that you say, hey, we're going to file in state court. This is a very straightforward legal issue. The existence of the rule, I don't think UF is really wanting to try to, and here, remember, it's not UF. Okay, it's Denzel Aberdeen. He's the individual plaintiff, but it appears, from a support perspective, that they would support him in that and that he would go forward to do that. So it may mean they're paying his legal fees or whatever, but he'd have an independent lawyer who would represent him. So I would think you would file that in state court. You can't necessarily dictate who your judge is. When something's filed in state court, they are randomly assigned and it kind of goes down. And if you have 3 judges in Alachua County, whoever the last judge is on the next filing, it comes in. It's a very similar scenario that would happen in federal court. And you got to remember that there is a federal court in Gainesville, a physical courthouse, and so for the entire middle district, which goes from Jacksonville and then, believe it or not, all the way down to Cape Coral.
Yeah, I can say this. I can, and you guys tell me if you agree with this. There's some logic here. This new rule notwithstanding, okay, there's 300 Division I basketball programs. Surely there's a lot of precedent for guys who barely played as a freshman that want to play another year that have won a case or lost a case or something. I mean, I got to believe that's what's interesting. On all these stories you read, I would think they would say, well, back in '97, the St. Bonaventure, wouldn't you think there's a lot of precedent for guys who played a few minutes and then didn't play the rest of the time?
Absolutely. And, the other thing is what you were saying, I didn't even think about the roster management angle.
Yeah.
But that would be something that I would argue on behalf of Denzel if I represented him, right? Say, hey, they weren't saying they're pointing this towards Denzel. They weren't pointing this towards guys that did 41 minutes. They were trying to make a decision, for rosters and other stuff. But, here, the court's only going to look at this case, how it affects him, and go into these, these 2 balancing tests, right? And one is is the irreparable harm and likelihood of success on the merits, right? And so the harm is clear, right? Can you ever play college basketball again? Are you going to ever be able to play with, Tommy Houck and Alex Condon and kind of go on this run and all of those types of things? So the irreparable harm's clear. And in some of these injunction cases that we've discussed, likelihood of success on the merits could be a little bit tougher argument. But because of the timing and this new 5-year rule, I think it's, pretty much a slam dunk. So I think UF is laying back. If the NCAA grants him, there's no need for a lawsuit. It's over. If not, then you kind of time it up at that point in time and go in. What would be interesting is if they did get an adverse ruling on that. I know Denzel's ready to go forward. I know Todd would be ready to go forward, but I don't know how would the athletic association or what have you look at it if later on you could be deemed to be ineligible if you weren't successful in the injunction.
And there's no liability for Florida from an NCAA perspective. Aberdeen's with the team. He's working with them. Obviously, they've started, training for this coming season. But really, until he plays in a game, like he could be with the team up until basically the opener. And if he didn't get his ruling, it's no big deal that he's been involved with the team, correct?
That's a good
Correct.
question. That's a good question.
Correct. Yeah.
He's okay.
He's okay.
Because they surely by now wouldn't have been doing this. If where do you think it's going to land?
Because it doesn't seem like they're holding him out of anything.
No,
it seems like he's doing
They seem convinced he's going to be eligible, which is why I wonder if there's got to be cases where there's some guy from St. Mary's that played 12 minutes and won a case 8 years ago. You got to believe that's out there, or they wouldn't be doing this.
My prediction is that Hunter Hastings will be wearing the Denzel Aberdeen jersey that he had in San Antonio, the only guy that had it.
But did he go back to 11? I think is he going back to 11? Or is he wearing 1? Because you may, Hunter, you may have to rip one of those ones off. I mean, he won't want
it's
it.
all right.
Kentucky.
Either way,
you have to rip it
I
off.
think he's wearing an orange and blue jersey,
Okay.
and it's all going to work out. And I think the big thing with Sorsby is we hated the way that went. The athletic directors don't want to see it. These other athletic directors want to see the Denzel Aberdeens win because the same. The player who didn't play, they want to see him prevail at Kentucky and at LSU and, throughout the Southeastern Conference. So I think this is something that's pro AD, pro college basketball, and just good. If he was our son, you would want to see him win this to do that. We always would talk about, give up this 1 year so you could have, give up your 17-year-old year so you could have your 21 or your 22-year-old thing. Now you add in that you could go out and make a couple of $1 million. And, he's a good player. Is he really going to go make a ton of money in pro basketball? I don't know. So this is something that could set him up for later in his life and be part of a special team. So not just being a Gator fan or anything else, I would really hope to see a young man, win this legal case for sure.
Final thing. Let's go back to the Ohio guys. 11 of them or however many are suing together that, hey, now that there's a fifth year, I should get my fifth year. Are they going to win? What do you think?
I don't know enough about the individual facts in those cases, but I think they've just generally got a strong argument because of the 5-and-5 rule, and it'll be interesting to see, I don't know why. I'm sure they all have to have waivers set, right? Currently, why doesn't the NCAA just go and start addressing these and resolving the opportunity for litigation in these cases?
Because if they won that, I mean, you have to wonder how many football players or basketball players that go, hey, wait a minute, I suddenly have another year. Now it'd be hard for football because it's about to start. Right. But I really, if they won, it almost feels class action like. It's not, but it almost feels like that. So if they won. Is there a guy that was a fifth-year player at Georgia Tech that exhausted all 4 of his years? Said, wait a minute now. Right. Now I'm in play, right?
Well, yes and no. I think you're going to encourage a bunch of other people to come forward and file those lawsuits if they're able to prevail. But my understanding, it was filed in state court, right?
It was in Ohio.
In Ohio. So that's not going to be binding to anywhere else in the country, right? That's going to be something that you would go argue in those state courts, but you would have to, prevail under each of the locale, and that court would only be able to enter an injunction as it relates to eligibility for each of those individuals.
If Aberdeen's case does have to become a legal matter, if his waiver is denied, can his attorney argue football is gone just in the last few years? They've expanded the red shirt. It's now that you can play in 4 games, which is basically 33% of the games, and still maintain your eligibility. They have not done that for basketball. Could the attorney make an argument that's advocating for Aberdeen that, look, one of their sports, they've changed the red shirt. They've made the red shirt way more flexible.
All the time we try to argue, when you don't have direct precedent, you could say, hey, we know this is a basketball case, but I would point out that they've done this in football. Obviously, it's because they don't want to penalize people who've only had a small number of plays to lose an entire season and an entire opportunity. And I think that's something that would be influential on the judge. It's not directly binding, but it's the type of thing where you say, hey, look, applying those facts to this case, obviously, and that's why Denzel's case is so strong. And, the thing is that's different. If those guys had just been playing, all of the time and wanting to come get another year, the other thing is that the judge, when we talk about the irreparable harm, there isn't any real irreparable harm by one more guy playing basketball in college basketball. But there could be a lot of irreparable harm if all of a sudden you could have all these people coming in on the rosters. And so that's one of the large, unique differences between those cases, and one of the other reasons why I think UF, and rightly so, distanced themselves and said, hey, let's go handle Denzel's case individually because it's so strong legally.
Brett Hastings from the Hastings Injury Law Firm.